Thank you for your testimony, Kathryn. So I imagine you have copies of some non-disclosure agreements that you've seen.
Yes.
And then if you could provide some of those to the committee. I'm not sure we have them provided yet, but I think it'd be helpful for the committee members to put our eyes on exactly what's being what the language is in these non-disclosure agreements. Can you describe to us essentially what we all know what NDAs are generally, but if in these situations you have, well, let me just ask you, and then you can describe what they say. Are these situations where someone, like in your son's situation, is now at the age of majority, so he's 30 years old, and he's reporting a crime, he's communicating a crime that took place, in this case, 21 years before? Are we talking, when we're talking about NDAs, are we talking about those situations where someone who can consent to such an agreement, a 30-year-old, in exchange for a settlement from the hospital, is agreeing to sign one of these NDAs?
So first of all, we're not talking about the criminal sector at all, right? So we have the criminal laws and the civil laws. We're only talking about civil laws. We see these.
Sure.
So, and they're a clause. They're actually not an agreement. They're a clause within a settlement agreement that prohibits both parties from speaking. Now,
for prosecutable crimes is what you said, though, correct?
Well,
and I'm just trying to understand specifically what the language in the agreements is referring to.
Well, lots of jurisdictions say unenforceable, void, contrary to public policy, right? We can't have them for covering up crimes. But here's my point. Survivors don't know that.
Right.
Right? So, yeah, they're contrary to public policy. I believe any judge would throw that out immediately. But I'm just saying overall, victims don't know that. Survivors don't know that. I mean, they're already struggling, right? And it's very hard for them, to wrap their minds around that. And there's also a piece, with victims of child sexual abuse. They're desperate to get this behind them. They're desperate to find a new day, right? And so they feel there's a loss of power. And that's the other piece to this. There is this imbalance of power when we're negotiating these sort of agreements, right? So, to answer your question, generally it's a clause within the settlement agreement, and some of them will have, you can speak to your spouse. They'll limit the amount, the prohibition on disclosing any material terms. Some of them also say you can't, speak about the amount of the settlement, so they vary per NDA, but essentially they tell the survivor, they tell the plaintiff, they cannot talk about this. And this is really dangerous because if they're silenced, like I said earlier in my testimony, then that means we don't know that an institution has failed, right, and continues to have really crappy practices, procedures, standards, training, all of that. So therefore, our children in the future are in danger, right? But they also can't speak to protect children, to say, I think it happened to this one, I think it happened to another person. And then they have that guilt of not coming forward and sharing that information. So it's a real danger to children prospectively, right? It just puts children in danger.
Sure. Elizabeth.
I can speak to some of the specifics of the language in Kanakuk NDAs that I've seen. So, a lot of times people will say, well, actually even Kanakuk said the plaintiffs requested the NDA. And if you ask the plaintiffs, they will firmly deny that. And when you read what's in these NDAs, it's unilaterally silencing the victim. And these are 3/4 of a page long, not your simple confidentiality clause that protects the name of the minor plaintiff or the child sexual abuse victim. Language including, you will not disparage Kanakuk, its officers, its agents, its counselors, its staff, blah, 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 long list, either in media, on social media, to the public in a hearing like this. I'm here to represent the voices of so many victims of Kanakuk abuse who feel unsafe to speak out. And whether or not the exact language in their clause prohibits them from being in this room today, they sure feel intimidated into remaining silent on what happened to them, with fear that Kanakuk will come after them because they've done that. So when I said earlier, we're using the term NDA broadly, but these show up in settlement agreements as a confidentiality clause, a non-disparagement agreement. They go by different names. But the moral of the story is we're silencing child crime victims, and they don't know their rights necessarily, as Kathryn mentioned. And so they just take it as, okay, I've got to take my money and shut up and not speak of this again. And it protects the institution, right? And it doesn't, if they can't come forward publicly like Cindy was able to, then other victims are also still in the shadows. And that doesn't serve the public good.
Cindy.
I just wanted to add to, I did not, I said, I did not sign an NDA regarding silencing a victim at age 30 or in the 20s and them hoping that it puts something behind them. I mean, I understand that feeling, constantly wanting to put it behind me. I'm 54 and I've been dealing with it since I was 12. It's a lifelong journey. It doesn't matter how much money anyone receives in a settlement, they will continue the journey of healing and living outside of shame. When my story broke, I received countless messages privately on Facebook and Instagram, and one of them was from a 90-year-old woman who told me she was abused, sexually abused at 14, had gone to at least 20 different counselors in her lifetime, and finally felt different when she heard my story and when I spoke out. It was like I was her voice. So if a 90-year-old lady is still living in shame and trying to sort through the brokenness of her life, I mean, it's not going to end with a settlement. It's a lifelong journey. And to tell someone they can't speak of that ever again, I don't know how that could ever be in the best interest of a victim.
So just so I understand, I agree 100%. Just so I understand the timeline. So you were 12 years old in 1982 when the
Correct.
abuse started, correct?
Correct.
And it continued on for how long?
A little over 4 years.
Okay.
It was 1987 when I told.
And then when you told, and he was so in your instance, he was at a different church at the time. They suspended him, I guess, for 2 years while he underwent.
That's what they said, but
That's what they said,
there's
right,
evidence.
Right. So,
different.
and then he became at some point or started Gateway and became the senior pastor at Gateway, was there for a long time.
24 years.
There are reports that he was, had an estimated net worth of over $100 million.
Correct.
Certainly one of the biggest churches anywhere in the world, was one of the leaders, and at that time the president's faith advisory board. It's crazy because I myself listened to his sermons on numerous occasions. I have one of his books at home.
Right.
Don't have it anymore. But during that time, so in 2000, when did you approach through your attorney when did you initially report it through your attorney to the Gateway Board of Elders or to the church?
There was an email sent from me personally to Gateway in 2005, and there was some dialogue that went back and forth for approximately 6 months with Gateway and Robert and Debbie that ended with a phone call, and he was pushing me to tell him a figure that would keep me quiet. That this is out there, I believe, pretty public information at this point, and I responded with, there's no amount of money that could ever correct this, and I did throw out a figure, I think at the very end, because he just kept pushing, for $2 million. He immediately said okay and ended the phone call. It was about a year and a half later in 2007 when my attorney, Gittner Drummond, who is now the Attorney General for Oklahoma, sent a letter to his attorney asking for $50,000, and that was in 2007. And he laid out the dates and my age in that request for $50,000. I had accumulated up to around $25,000 to $30,000 of expenses that I had spent in counseling up to that point. And we just thought it would be reasonable to request for an additional $25,000 to continue to go to counseling. I was 37. I had 2 sons at that time and was pregnant with my third. So, when they responded with, it was my fault that I was the one that had pursued, and, he had basically been the victim, was how they responded. And then said they would like to know who I was going to for counseling. They would be willing to give me $25,000, and they wanted me to sign the NDA.
Did they send you an NDA to review?
I don't have it. If they did, I know that Gittner spoke to the attorney, and there may be some documents still in the file pertaining to that.
Yeah. How did that make you feel when they asked you to sign an NDA?
Well, I'll be honest, I had never been in any type of business or legal battles at all, so I didn't even know what it meant when he said NDA. I said, "What is that?" And he said, "Well, it basically means you won't be able to talk about this anymore." And I said, "Absolutely not." Like she said, they're controlling me still. That's how it has felt. Like they still have control of my life if I did that. And like you said, you've listened, like hundreds of thousands, if not millions of people have listened to him preach for the last 25 years. And I was not one of those. But since my story came out, I have seen many of the short reels where he blatantly lies and shares my story and twists it to his benefit, still portraying it as an affair, calling me a Jezebel spirit, just building his wealth off of my story, but twisted in lies.
So it's just devastating, and you've been so brave, and we've all followed the story and read and watched all the documents, and thank you. Recognizing, I think one of the sad parts among many for me is that there are millions of people, of victims, boys and girls who are in your position who aren't yet quite ready and may never be, and that's totally fine to speak publicly about it. They're in the shadows now. And the fact that many of them have signed NDAs simply because they may have needed the money to pay for counseling.
Right.
And Kathryn, are parents signing NDAs on behalf of their minor children?
They have the power to do so.
How do they have the power to?
Guardians can do this if they step in the.
But once the child becomes.
Yeah, you don't usually see that. You usually see it much older, primarily because it takes victims a very long time to come forward. But I just wanted to point out one other thing that makes this very applicable to child sexual abuse claims. Many, many survivors cannot emotionally withstand a trial. Mm-hmm. They just can't. They may not even be able to get through discovery and depositions and all of that. So that's why we see a lot of survivors saying, this might be the best route. And some really good attorneys will advise their client, this is going to be very, very hard for you. You're going to be re-traumatized. We've seen survivors end up having to be, put into a psychiatric ward in a hospital as they get closer to trial or right after a deposition. It's extremely traumatizing. So you just see more settlements in these types of cases.
Can you help me understand in the situation, like for instance in Cindy's situation, where clearly his attorney, probably his wife, and certainly some of the Board of Elders knew that this had happened. Are they not mandatory reporters? How are people requiring victims?
Were they then?
Were they then?
I don't know if they were then, because it's when the abuse occurred that they would be a mandatory reporter. unless I'm misreading the Texas law.
So, I need to have a better understanding. One of the
Yeah.
things we're also going to discuss, I believe strongly we need to discuss, is escalating the penalties for mandatory reporters.
Right.
But were they
'Cause they're
not
typically
then,
minimum.
were they not then at the time, considering he was still the pastor, mandatory reporters?
I don't know the answer to that, but it would certainly.
Elizabeth, jump in.
The statute on that is very short. But I want to respond to your question about parents signing NDAs on behalf of their minor children. We've seen it a lot in the Kanakuk cases. Logan Yandell, who is a public plaintiff suing Kanakuk for fraud, civil conspiracy, and negligence right now, he was put under an NDA by his parents. They agreed to a quick settlement, trusting Joe White's narrative about the abuse by Pete Newman at Kanakuk. Evidence shows quite a different narrative right now. But when he initially reached out to an attorney as a grown person, not a minor, later on, wanting to talk about this, the attorney told him, well, you will have to sue your parents to get out of the NDA that they signed when you were a child. So that's the position child sex abuse survivors, child trafficking survivors, child crime victim survivors are put under when their guardians may not be educated about what the language of an NDA exactly means. What is the ramification on their child's life? And so that's why we're fighting, the Kanakuk survivor community is fighting this NDA issue, because a lot of these victims were silenced as children, and they're now adults ready to speak out and legally cannot.
Is it your position, either Elizabeth or Kathryn, any of you, that the state should, just as a matter of public policy, void all make it, just prohibit anyone or any organization from being able to ask for an NDA for, quote, prosecutable offenses? Is that, how would you describe that, or how would you define it?
I think that they should be void and unenforceable for child sexual abuse claims, period.
Void and unenforceable, so what would the penalty be for someone even asking for one?
That could be another step,
Right.
right? Certainly that.
Mr. Chairman,
Yeah.
I want to jump in
Yeah.
to your
Chairman
question, and I'm directing it to you. I think that we're not explaining it well. You still want to make sure that if there's agreements in place, that they maintain confidentiality of the victim. So for the parties that are not the victims, the individuals or the company or institution, they would still be obligated, if that was the wish of the victim.
Correct.
They can't go disclose. This should be a right that only the victim and the victim's guardians or parents have the ability to do.
Agree.
Okay.
Agree, well said.
I can read a sentence of specific language that Tennessee passed, if that would be helpful.
Yeah, it would be.
Okay, so notwithstanding any law to the contrary, any provision of a settlement agreement that has the purpose or effect of concealing the details relating to a claim of child sexual abuse is void and unenforceable as contrary to the public policy of this state, except that identifying information concerning a victim of child sexual abuse shall be deemed and maintained as confidential.
Was that in, you said that was Tennessee?
That was Tennessee under Governor
Was
Haslam
that
in
prospect-
2018.
Was any part of that retroactive? Did it void existing?
It says void and unenforceable.
Do you, Kathryn, Kathryn, you're
Which
not
is
from Texas,
prospective.
right? Where are you from? Are you from
I'm from Connecticut.
Connecticut? Okay. So I don't know if you've been able to thoroughly research Texas law, but I would like an opinion as to whether the legislature can void existing NDAs.
I would say unlikely.
Unfortunately, I would agree
Yeah.
with you, but
I mean, you do
That
have,
language that you
a
just read from
provision in your
Tennessee certainly-
Constitution as well on
say it again.
retroactivity, so.
May I, Chairman?
What, Representative Scove?
You're going to make me go back and look at our 200-page Constitution, but I think there's actually a provision of our Constitution that prevents the legislature from interfering with existing contracts.
Yeah,
That
the
is certainly
contract clause.
there, but
Yeah.
if a contract is already void and unenforceable as a matter of public policy,
Yeah, that's going to be,
I agree.
I think functionally, that's how it would play out. You can't go and undo what's in the agreement, but if that party then tries to enforce it, the party on the other side of it can say, no, this should be null and void. Look, even the legislature's spoken and said these are against public policy, and the court at that point would probably say, you're correct, we're not going to enforce this provision, then they are doing it, not us interfering. I think that's functionally how it would work.
That's how it is working. There's precedent on that in different speak out applications of the Speak Out Act, such as in South Carolina. That's what we're seeing on that issue.
I think the hope would be is if the legislature engaged in something similar to that, the message is very clear, and parties trying to assert that provision probably are not being well advised by their counsel.
Sure.
So I mean, my hope would be that when you make a public policy statement like that, because you're laying a marker down, right, as the policymakers in the state, you would hope that is not something that will have to be further litigated because it's very clear in the law. But again, you never know. But those are some of the things that would.
Well,
I don't think it is retroactive in that sense.
It's
saying any going forward can't include it, but it's also saying, I think, if someone tries to assert enforceability of this one, there's going to be an opportunity for that victim to say, hey, I know I signed this, but this should not be enforceable, and the court could make that determination, and probably would.
well,
I mean, it could be like any other contract offense.
Yeah, that's what it
Mr. Chairman,
yes.
I
Representative Slauson.
recognize that the value for the perpetrator of these NDAs is in large part the chilling effect that it has on the speech, and it's not necessarily the recompense that they might want to receive for a violation of it. So to that end, my question is, how often do we see offenders trying to enforce the NDA provisions when someone finally works up the courage to speak out anyway?
Great question.
I can speak to what we've seen in the Kanakuk cases, and when a family got down to the wire, ready to sign on the dotted line, they saw this NDA. Their counsel was trauma-informed enough to say, this is the ramifications of signing that. They refused to sign that NDA. Then Kanakuk sanctioned them. And a judge fortunately ruled, like, this was settled. We're not arguing over this anymore. And they got out of the NDA. But Kanakuk came after them for refusing to sign that clause. That's how important it was to that institution and how intimidating they were willing to be to get that family to sign away their son's voice. And it cost them $40,000 out of their pocket after already re-traumatizing and expensive legal process. So that happens in the survivor community of which I'm involved. I don't know more broadly, Kathryn, if you have other examples nationally.
No, I mean, just generally, I don't. But I'm happy to take a deeper dive if that would be helpful to this committee.
I think it would just be interesting in the context that you were just speaking of the probable inability to create a retroactive looking law versus the comment about sending a message in general about how we would view it in a cultural, political, perhaps judicial context, even though the law couldn't apply backward. It would just be interesting to know how often that comes up anyway.
You certainly have the power to pass a law prospectively.
Well, it's a great points, Representative Slauson. I'm thinking about a situation where, let's say, within the past 5 to 10 years, someone entered into an NDA that still requires future performance, maybe future payments, maybe annuity payments from an organization to a victim. And if that victim, if we pass this law and that victim then speaks out in violation of an NDA, is that a material breach of the agreement, therefore excusing future performance by the other party? Can they then take the position, well, you've breached this NDA that we signed 5 to 10 years ago, and therefore we don't have to make any future payments to you? Does that make sense?
I'm just thinking, I hate to be too legal on this, but in terms of arguments to make a contract unenforceable, like frustration of purpose or impossibility, something like that, you can see it as something happening in the future, unconscionability. I mean, we have all of those in contract anyway.
Yeah. Members, If you could, I know all of you have done a lot of work on this. If you could just continue, you say you don't want to be too legal. This is the Judiciary Committee, and so we're used to it and we welcome it. We want to make sure we get this right. The Tennessee language sounds strong. We, of course, would want to make sure that it works. Something like that would work here in Texas. And the goal here is, of course, to empower victims, victors, as I like to say, to empower them and provide them the full support of the state when it comes to seeking justice and holding wrongdoers responsible. I also want to, and Elizabeth, we've talked about this, and we don't have to cover it here in the hearing, the desire for the wrongdoers or these organizations to cover this activity, and in many cases to cover for wrongdoers who are still out there on a daily basis being exposed to and having full access to children, whether it's camps or churches or Boy Scouts or sports. I mean, they're still there. Texas is in many ways, looking at what other states have done in this area, Texas is behind we are behind where we need to be and where we should be. Mm-hmm. And I fear that if we don't act in a real meaningful and strong way, we're going to almost become a sanctuary for these criminals who are preying on our children.
Yeah, and I do think that if the focus can be, in sort of a dual focus of, one, protecting survivors and letting them have their voice and not be re-traumatized, right? But the other really important piece is the connection of NDAs and the harm to future children, right? Mm-hmm. Look, I believe nothing good ever comes from a secret, right? And if we allow NDAs and child sexual abuse, we absolutely put children in danger in the future.
And to your point about the hidden predators who are going on to harm children, I'm just thinking from Cindy's story, she refused the NDA, but how many people that were victimized by Morris signed it?
I'm going to add one more thing about the protection of the future children, and that is what Sergeant Mike said. He asked the question to a room of survivors, how do we stop child sexual abuse? Our answers were no sleepovers, just common sense things to maybe protect our children. The number one way and the only way to stop abuse is to tell. And if we have to sign an NDA and we can't speak out about it, no one else is going to know, and they will be continued to allow access to children. I have a personal story with my own son as well. When one of my sons was 14, I believe at the time, and there was a father of another student at school that I caught grooming my son. And I was able to inform the school. I called that father directly and told him to not speak to my son, to stop texting him. He did not argue with me. He said, okay, which was an immediate red flag that was exactly what was happening. I was able to inform another parent whose son was very dear friends with this man's son. And 3 months later, the police were called because he had sexually abused that boy, and he finally told. And that man went to prison because we told. So whether you're telling when you see it, the activity happening, whether it's grooming, any flag, or you are able to tell after you gain the confidence, that's the only way this is going to stop and protect our future children.
I agree. Members, any other questions? Thank you to each of you. We're going to have you back. I can't remember which one of you mentioned at the top of your testimony that if the legislature decides to do something on this next session, be assured that the legislature is we're going to make movement on this, meaningful movement on this and other issues next session, and we hope that you'll come back and help us actually pass meaningful legislation.
Yeah.
Thank you.
Thank you.
Mr. Chairman,
Yes.
before I want to thank you all for being here, I want to add one, not particularly on straight on topic with what the women here have spoken about, but it has been a topic in this building over the last several sessions about sexual harassment in this building. There certainly are offices that engage in having staff sign NDAs. I think it's something that we should look at. I know that we've looked at the federal level and other states on sexual harassment and workplace NDAs as well. Not particularly on the topic we're talking about here, but adjacent to it. And I think if we're going to talk about these standards outside this building, we should be talking about the standards inside this building. So thank you all for being here.
Well, on that, so does the federal law that was passed not apply to, because it is specific to sexual harassment claims, correct?
Sexual harassment in the workplace.
Post-dispute.
Say it again?
Post-dispute NDAs for sexual harassment in the workplace. So I'll send you the exact language and what several other states have gone to emphasize and go a step further at the state level based off of what the Speak Out Act was drafted to accomplish.
Okay. All right. Great point. Thanks to each of you.
Thank you.